Call to order. It's Monday, July 20th, 2026. Madam Secretary, will you please call the roll? Present.
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 Present. Present.
Thank you. Agenda item number 1, the board may discuss and vote to approve the minutes of the meeting of July 7th, 2026. We've received the minutes and trust had a chance to review them. If there are no questions or changes, I ask for a motion to approve.
Motion approved. Second.
Moved and seconded. All in favor signify by saying aye.
Aye.
Any opposed? Any abstentions? Motion passes. Agenda item number 2, the board may hear and vote on the objections to nomination papers that have been filed in accordance with the requirements of Rhode Island General Laws 17-14-13 and 17-14-14. The nomination papers submitted on behalf of Jasjit Gotra, Governor Independent, and Allison Kane, State Committee Woman, District 45, Democrat. And I think, Ray, are we going to you first?
Yes, if the parties for the first matter can come up to the table if they wish. And they can identify themselves for the record.
Just gotta press till it turns green.
You gotta kind of hold it down.
Thing's gonna be no.
John, just hold it on for about 5 seconds.
Yeah, you gotta
It'll
hold
go.
it down.
It's very temperamental. It's not.
It's time for right now.
We may have to get assistance on those then.
Technical
We got-
assistance.
we got technical assistance for you, no worries.
I know, he has the magic touch, I'm telling you. It's not
It
you.
happens every time.
It's not you.
Attorney John A. Pagliarini Jr. for the Ken Block campaign.
Jasjit Gotra, running for independent candidate for governor of Rhode Island, representing myself.
Great.
Okay, thank you. Madam Chair, if I could just spend about 5 minutes, maybe just addressing the legal issues, just to give some parameters to the challenges to the hearing that we're about to proceed in, and then certainly provide Mr. Pagliarini, Mr. Gotra the opportunity to respond to those comments that I make, and then you can make your own determinations. So the first matter that we have today appears to me that the standing is satisfied. Mr. Pagliarini is here. He's counsel for a gubernatorial candidate, Mr. Kenneth Block. So we have satisfied, in my view, the standing component. And Mr. Pagliarini, on behalf of the candidate, raises 3 specific challenges to the nomination papers. And the first one contends that the number of endorsers must be stricken, a number of them must be stricken, because they were mandated by the statute to not only sign their own names, but to also personally write out their names on the nomination forms as well as their addresses. So if they signed, but someone else, even with their permission, may have added the other data, the other fields on that form, they should be stricken as not satisfying the governing statute. And the governing statute here is found under Title 17, Chapter 14, namely 1714(8). And thank you for putting that up on the screen. And that's the language that governs your decision here today. Now, Mr. Pagliarini argues that the requirements under this statute must be strictly construed, namely narrowly applied, as opposed to generously providing remedies to the parties or application. And our Supreme Court rejected that very argument for this very statute, albeit a different version, somewhat different version back in the 1950s in the case of Coleman versus City of Woonsocket. And in that case, the court found that contrary to the position of the petitioner, the statute in question should be liberally construed. So that would be a more generous interpretation by you when affording the decision and the rights to the parties who are preparing nomination papers as the one in this case. That case is Coleman versus Board of Canvassers and Registration of City of Woonsocket. The court explained that, I'm quoting, "where the signature is admittedly valid and the elector actually is registered from and lives at the place of residence as indicated, and where no fraud or misleading circumstance which might confuse the board in identifying the elector is shown, and where nothing appears to exclude the fact that the elector has authorized another to add such place of residence, a liberal construction of the provision under consideration would be in keeping with the intention of the legislature and the purpose of the underlying statute." And then the court went on to say that in the circumstances here presented, we find no sufficient reason to show why such language would necessarily nullify an elector's valid signature to which his correct place of residence was added by another person. So this is directly on point. It was stated by our court over a half a century ago, and it's been this in my years on this board, it has always been our view that it is the signature that must be penned by the endorser. The other information, so long as it's accurate and was approved by the endorser, can be added by third parties. So that should guide you with respect to that aspect of the claim, and then you have to make your own decision on that. And we will hear from the parties in response to what I just said. The next contention by the petitioner is that a collector of signatures for nomination papers cannot sign and endorse his own signature. And there's really no statute or case law that I found that is directly on point on this matter. But this statute, 17-1410, does require every person who obtains a signature on nomination papers to sign an affidavit under oath stating that the, quote, "signers of the within nomination paper did so sign the paper in my presence." The signature contemplates a clear distinction between the role of the collector, who is witnessing others' signatures, and the role of the endorser, the voters who sign in front of that person, the candidate. So when a collector signs as an endorser, they cannot then testify that their signature was done in their own presence, since to do so would offer you no objective way of corroborating that information. So in my view, and you'll make this decision, and we'll hear from the parties, that claim by the petitioner appears to me to have merit. The next contention by the petitioner is that the signatures must be rejected when it only includes the initial of the endorser's last name. So again, looking at the governing statute, it does say that a variation of the voter's signature by the insertion or omission of identifying titles or by the substitution of initials for the first or middle names or both shall not in and of itself be grounds for invalidation of the signature. So we have the General Assembly is speaking to a permissive reading with respect to the first initial of the name and the initial of the middle name, but not of the last name. And I think that should likewise govern how you review these nomination papers. There's one caveat to that, and that is in the very same statute, it does say that signatures shall be accepted as valid if it can be reasonably identified to be the signature of the voter in question. So in my interpretation of that statute, if there are signature specimens on file in the CVRS that show that this person, this endorser, has routinely on record signed his name where it appears that the last name is basically the initial and then trails off, for example. If you can conclude that that signature specimen matches the signature from the nomination papers, in my opinion, it should be accepted. And then there's one more contention, unless there are others that that I may have missed. But the last contention is that where the endorsement papers do not include information in the particular fields for address or their name, it should be rejected. And a reasonable interpretation of the statute would support that contention. That information is required by law. Now, like I said in the Coleman case, the court said that a third party with consent can add that in, but it must be there. So in my view, and that will be your determination, if there is a nomination paper that lacks that information, that is facially invalid and arguably should be rejected by the board. Before leaving these analyses, I should also just speak for a moment on the idea of mootness, and that may or may not come into play in this case. But on mootness, if you have before you a case where you cannot afford a remedy that will change the outcome, even if you were to provide all of the remedies being requested by the petitioner. So for example, if there was a need to have 1,000 signatures and there were 2,000 signatures that were offered, and there were only challenges to 500, then it would follow that under no circumstance could you afford any remedy to that petitioner. And that would make it a moot matter that would not require you to take any decision whatsoever in the case. So I just want to also bring that into focus. It may come up here, it may come up in other cases that you hear today or on Thursday. So with that kind of like guidance and direction, I think it would be appropriate now to hear from both Mr. Paglarini as well as Mr. Gocher to respond to those.
Right, do they need to be sworn in or?
Well, no, Mr. Paglarini would not. He's
No.
not going to be
Okay.
able to present any facts. He's counsel. If Mr. Gocher does assert that he wants to present facts, he should, but if he's here just to present argument, he does not.
Okay, all right, great. Mr.
Thank you,
Paglarini.
Madam Chair, and thank you to your legal counsel. I'm going to first go to the question of mootness. I understand that. That's an appropriate position. However, in Mr. Gottra's response, I want to give him credit. He made a statement about guidance. And even if you reach a point of mootness, I would like the board to rule on each one because this is such a blind spot in election law that your guidance is needed. And if you can come to a decision on each of those questions, even if it doesn't change anything, I believe you should, because it might change the next appeal that somebody brings before this board. I think that we agree with the collector cannot sign his own papers for the reasons that your legal counsel gave. Going to the last initial, I think the fact that the General Assembly did not give an exception for the last name states that you cannot do it. I concur with counsel that if it trails off and it's just a scribble, then it should count. But if it stands alone that I just write John A. P., it should not count. It should be invalidated. But if there's a trail, then it should count. Putting ditto marks does not meet the standard of somebody putting the address according to 1714-8. So that leaves us with the main body of this appeal. And if I may provide a copy, an exhibit, who do I give it to?
Have you given it to Mr. Gocher
I
first?
will give him a copy.
Just so he can see it. And I would, if you could, just take a moment. And Mr. Gocher, let me know if you have any objections to that being marked, and if so, what the basis is. Marked as a full exhibit. And why don't we just hold off 1 second on providing, just until we see if we can mark it as a full exhibit. John, can you just kind of give a summary of what it is? Is this a position or is it?
All right, it's
The copy shared.
It's the copy of your Rule 10.4B. which is identical to the statute that is on the screen. However, we provide an excerpt from the holding of a 1970.
That can be given out.
And the excerpt of a 1976 case, Gorman versus the Board of Elections, Rhode Island Supreme Court, August of 1976. And I'll read it. It says, contentions similar to those now being made by the petitioner were rejected by a majority of this court in Mallow versus Board of Elections in 1970. There, as here, the candidate asked that this court apply the doctrine of substantial performance. However, the majority pointed out in Malinow that the exact conformance requirements of 1714-8 serve a real governmental purpose in that enables the local board of canvassers in all the municipalities of the state to check nomination papers so that they can report to the Secretary of State, and in turn, this official can take the necessary steps so the ballot will be printed and distributed in time for the primary. The remedy for the petitioner's present difficulty is to be found in the legislative rather than judicial branch of government. So I offer this because what your counsel described from 1950s was directly on point, but it talks about the doctrine of substantial performance, which I proffered to you was rejected in 1976 by the Gormley case and has been followed in a subsequent case, which would have been in 1997, Boucher versus Bejan, where they're saying it's exact conformance with 1714-8. And that's what we rest on, is that I didn't file an appeal and allege that there was systemic fraud involved here. That's not where we're going. This is about, there's 21 sheets that were submitted. When you review those sheets, and in particular, if I draw your attention to sheet number 157, when one person fills out column A and column B on 20 consecutive lines, it just raises doubt. And that's not what the line on the wall behind this board says to protect the integrity of the electoral process. To protect the electoral process, its integrity, the voter, according to 1714-8, needs to fill out their name printed, their address, and then sign. And that's the basis of this appeal. Thank you.
But John, the current version of this statute, wasn't it actually amended to address the fact that the court in these cases, namely Malinow, had a strict construction of the signature requirement and found in that amendment that it should be a reasonable interpretation? That's my recollection of it.
I believe that Malinow, Gormley, and Boucher all go to an exact interpretation, and if you have any difference with it, you go to the General Assembly. But I believe this board is bound to read exact, which says the voter shall sign in person, not anybody else.
But those decisions dealt with people who were not affixing their suffix or the prefix, and were not signing their full name exactly as it occurred in the voting records. And for that reason, so it was a focus on the signatures.
I agree with that.
And then the General Assembly put in the signature shall be accepted as valid if it can be reasonably identified. So it kind of moved away from the doctrine that was espoused in Malinow and many other cases for that very reason.
But the statute says, and the cases say, not just focusing on the signature, it says the exact wording of the statute. And the exact wording of that statute is that the voter will fill out columns A and column B.
But that's where, isn't that really the question? I mean,
That is the question
If-
before
if-
this board.
if it did say that, and by the way, the 1952 version used the word add, that the voter shall add the address and the name, and that was found to be still something that so long as a third party did so, it was permitted. Number one. Number two, the other thing that I found interesting in Coleman is that what the court said is that by analogy, look at what is required when you have a voter registration. The only thing that the voter must sign himself is their signature. The clerk or others can actually add in other information in the voter registration form. And they use that by analogy, saying, we have a system here where the very focus of the board's analysis and the state's analysis is a signature comparison. It really doesn't go to who wrote out the other information, because that information, so long as accurate, can lead you to the right signature on file at a time when we had a paper system. So I think what John is saying makes sense. I understand that position. I respectfully disagree that there is anything that must be strictly construed with this statute. And that so long as the signature is penned by the endorser, then the remaining, so long as it's permitted, authorized, can be done by a third party.
And I disagree with that interpretation, respectfully. Thank you.
Madam Chair, I just have a
Yes,
question
sir.
for council. So council, is it your contention that a voter signing the nomination paper has to sign his name, write his or her place of residence with their street number and everything as it appears on the voting list under the case law?
Yes, with the exception that I will concur with counsel that the signature is reasonable, but I believe they're required to do their name and their address. What would you do if I came before you with a typewritten list?
In the event of a voter who can't or uses an X to mark their nomination paper, what would they do?
There is an exception in the statute that requires that two witnesses be present. That's the only exception
For their signature,
for their signature.
right? But that doesn't reference their address.
That is correct. I think, now we start down the slippery slope. One would have to, if they can't write, allow it.
Right, and you
But it
don't
would
think,
be witnessed by two persons.
but in this particular case, it says sign in person with his or her name, comma, place of residence, comma, and street number as it appears on the voting list. It doesn't specifically say sign his or her name, write his or her place of residence. Correct?
No, I disagree with that. I believe it does very clearly. It says the voter shall. Doesn't say the collector shall. Or may.
Well, for me, I would disagree, but okay. That was my question, Madam Chair.
Okay, thank you. Any other questions for council? Commissioner Giacone?
I just had a question. Which sheet was it that you said? You said one.
157, upper right-hand corner.
I don't see
I don't know
that.
to find that. I don't think I have that 150. I think I have that. So we provided you copies of the specific pages that were challenged as part of the objection, which is what the regulation requires. I think council is referencing a page where he's giving as an example, the first name, the name and the address were written in by the collector, but those are not something that the staff could identify which ones he was referencing. So that is throughout the nomination papers. We can
Do you
certainly
have it?
show that, but we don't have, that wasn't mentioned in the objection.
It was.
Well, I have an objection with him sharing that before I get a chance to speak.
Well, if it was part of the official record, though, I'm going to move it.
Well, so I think, Mr. Pagliarini, did you reference that in your filing but not attach the document?
I wrote, it is clear from the attachment that the collectors for candidate Gutra. So it was referenced as the attachments.
So
because
you have a
the
copy
form-
of the objection as it was filed.
The form itself requires you to list line by, but it's all the signatures. These are representative of all of them. I'd have to list 1,069 signatures. It was more efficient to reference it and incorporate it by reference. The collector filled out all of column A and column B, and it just doesn't bode well for integrity, because you look at it and you say, what is going on here? And I am not saying that any of those signatures are fraudulent. What I'm saying is, it appears as though it's problematic.
Well, what is problematic about it? If the signature matches, what about this conduct makes you think that something may have been that was untoward? I mean, one
I'm
scenario.
trying to not go down a road I don't want to
Oh,
go down.
okay, all right, fair
But
enough.
there-
Fair enough, that's
You know,
fine.
there's a lot of signatures that were disqualified. And I think because a lot of people's signatures are illegible. And then does the board go to their printing, if they happen to have that on the voter record also? It just doesn't meet the spirit of the statute that says the voter shall sign it. And when you look at an entire sheet in the same hand, it doesn't give anybody confidence, is all I'm saying.
A couple of questions.
Yes,
Miguel, how many signatures have been submitted and how many are at issue here?
We have a summary screen we can put up for you with the summary of the signatures there.
Yeah.
So you have, requires 1,000 signatures.
Yep.
There were 1,538 submitted, as you can see on the screen here, and 1,069 were approved, 439 were disqualified. 469, excuse me, were disqualified, and according to the objection, there are specific challenges to 11 signatures, apart from the contention with the name and the address being written in by the collectors. That would mean that 70 disqualified signatures would remove Mr. Gotcha from the ballot.
By one vote, by one signature. is that it?
Yes.
No.
I'm sorry.
John, I'm a little puzzled by here because a voter, when he goes to vote, he just signs his name. He doesn't write his address.
Mhm.
So, I mean, that's where the actual voter happens. And why should you take a stricter attitude approach to these nomination papers when the actual voting has a more liberal position on
Commissioner-
just signing
Commissioner-
rather than including the signature, writing the address?
My response would be that that's what your rule states, that's what the state law states, and in my opinion, that's what the Supreme Court of Rhode Island has stated. Exact.
No.
If you want a lesser approach, then the board should recommend to the General Assembly clarity. But until then, the court has said exact.
Well, the Coleman case said it could take a liberal interpretation of it. That's
don't-
always been the position of this board, a liberal interpretation. Do you have any cases where it says that this board has to take a very strict position
I
with respect to?
presented one to you, the Gormley case that was passed around, and it says exact.
But that Gormley case is my recollection, because the statute was passed afterward. That Gormley case talked about whether or not there was a suffix to it, whether the person signed as a senior or as a junior. And the General Assembly adopted the legislation afterwards,
In
says that where it could be reasonably identified.
In 1997, the Bousher case referenced the Gormley and the Mausher case. I'm not saying that correctly, but this has been the law in the Supreme Court on 3 cases, the 3 most recent cases. I don't believe 1952 is still good law.
Did you research the legislative history of 17-14-8?
I believe the courts have done that for us by saying exact.
But my impression that statute was amended after the last case.
go ahead.
Question for council.
Yes, sir.
Do you know how many signatures, specifically the number that you are challenging? We have listed here 11, but I
We-
think it's,
We provided 21 sheets. That is approximately 250 signatures that should be invalidated.
so question for Miguel, the 11 here, those are aside from where the collector may have added the address. Is that
Correct. Those are the specific signature challenges where the last name wasn't included, the address wasn't included, or the signature did not match.
So back to our main point with regards to mootness, we can't really look at that because they've challenged more than actually 11. And their challenge would be above that 70.
From what Mr. Pagliarini said just now, yes, I would agree, but do we have a record of the 250 that are being challenged? Is there a record of that?
I filed it with the 21-page attachment to it.
Identifying each of the offending lines?
No, as far as the form listing out all 250, yes, the sheets were attached as exhibits. Otherwise, one would have to go through and list 250. And if I may, the signatures were provided to me the night before at 11 o'clock. When I woke up in the morning, they were there in the email, and we had until 4 o'clock to file them. To go through and list 250 after finding them is just impractical. If you're going to make anything to the General Assembly, please expand it to 3 days, because
Yeah.
Mr. Gatra had almost 3 days to respond.
Yeah.
We had 8 hours to file.
Yeah.
Find the problem and file.
Mm-hmm.
I
Mm-hmm.
understand that.
Yeah.
So Miguel, do we have a record from, that actually has all of the papers that Mr. Pagliarini is referring to?
That was what was sent over to us from the Department of State. I can confirm that. But they are here. So Kathy Placencia is here from the Secretary of State's office. Did you bring the original objections? So we do have the originals today. So I can look at those.
And so really then you're going to require a ruling with respect to these kind of like broader issues. Can you accept it if the fields are blank? Can you accept it if someone else wrote in those names or names and addresses?
If the name and address was written in, we feel it's an invalidated signature.
Yeah, so that part of the argument, I think, is in the record.
Correct.
Did you want to say anything else with respect to any other aspects of your challenge?
No, thank you.
Okay.
Madam Chair.
Yes, sir.
So Ray, I have two questions for you. First of all, with respect to the sheets that were allegedly filled out with the name and address on them and then just a signature. If this board determines that that's not a viable objection, then the case would become moot, correct?
We'd have to make sure that we have quantified the number of challenges that
Well,
would
based
consist
upon the
of.
fact that what we've been provided is there's only 11 signatures beyond that.
So the only other aspect is just those fields not being completed by the voter himself.
If you vote against the primary question, you need not reach an answer on the others. I would ask that you do just for future guidance.
I know,
on
I
the
understand.
candidate.
Yeah.
I understand. And then the second question I would have, Ray, is, and I want to make this clear before the candidate speaks. With regard to those papers that allegedly have the address filled in, on an evidentiary basis, how are we to determine who filled those in? Before speaking to the candidate and having the candidate say
Well,
something that
You-
may or may not be in his
Right.
best interest.
Unless you have testimony, affidavits from the petitioner saying this was done by a third party, you are also able to use your own reasonable assessment as to whether or not you believe one person wrote out that information versus the filer themselves.
But that would be us making a decision.
You'd have to make
an
that
evidentiary decision on each one.
That's right, but I think the first decision would be whether or not you agree with the premise that it's not allowed. If you say that it can be done by a third party on behalf of the voter, that's your decision that would end the analysis.
I mean, I guess my question is, doesn't the fact that it was signed by a third party need to be done on preponderance of the evidence?
Yes, but you're not making that, you're not moving that evidence in. That's up to the petitioner to do so.
Correct. I'm just asking what basis we're going to use other than the fact that they may or may not look similar.
Right. Unless the petitioner has some other evidence, that's all you're left with.
Thank you.
Yes, sir.
Sorry, just some follow-up questions. I just want to make sure I have the numbers right. How many signatures total number, fall into the name and address category as in not written in by, or allegedly not written in by the person who signed? I just want to make sure I have the numbers right. So we have the 11 here.
Yep.
It's clear in the objection that there's a reference to the name and address ones, but I don't see the total number. I'm just trying to
Right.
get at the.
I think the staff might have it or might need to make that quantification.
Is it just
We-
that one sheet, 157?
No, there were 21 sheets totaling approximately 250 signatures. But I believe if we're going on a preponderance of the evidence, the candidate's response to our objection states that most of the signatures were done with that process.
The process of someone signing and then someone else filling in the name.
Correct.
Okay.
Yeah, like even the Coleman court, that spoke about evidence of fraud. We have none of that here.
I'm not saying fraud.
Yeah, I understand. So we're left with, Okay.
So my second question is to the executive director. We put a sheet together, I think, because we've had so many issues.
Correct.
Did the sheet specifically say, or our guidance, just the more informal, I don't want to call it informal, but the guidance that we sent out with the sheets, did it specifically say that the voter has to fill in name and address themselves?
No.
It did not.
No.
And then my third question is, something changed in the statute. I'm looking in our green books here. I can't clearly, between the case that you mentioned, something changed. Do you know what specifically changed?
yeah. From the Coleman case?
Yes, the original one that you mentioned, if that was, I don't remember the name, but.
Yeah, so back in 1952, when the court was ruling on this, here's the language that it quoted. Each voter signing a nomination paper shall add to his signature his place of residence, and each voter may subscribe to one nomination for each office to be filled and no more. So shall add to his signature his place of residence is the operative term. That language of adding to his signature has been deleted. But even under that arguably stricter obligation on this statute, the Supreme Court found that whatever that means, it does not mean that it has to be done by the endorser, it can be done by a third party.
Yes, go
I
ahead.
have one other question. I'm sorry, unless the commission's finished.
No, I'll say, I think that answered my
I
question.
have one other question. If we were to take the position, as requested by council, that everyone has to write their own address in, print their name, write their address, and then sign it before the nomination papers can be accepted, would the local boards not be required to do that as well under the statute?
Would they be required to follow that same view? Absolutely.
And when we review all of these nomination papers in the 2 or 3 day period that we have them, we would have to make a determination on each line as to whether the particular voter wrote his own name and address, correct?
That's right.
And that if we see something in the address that would indicate to us that maybe the person's significant other wrote that in instead of that person, we would have to deny that signature, correct?
Arguably, that's right.
If we took that position. Okay. Thank you.
Thank you. Yes, go ahead.
Another question for Ray. In your recollection, have we ever dealt with a challenge to this specifically? I know you mentioned the Supreme Court case, this board.
A challenge where somebody said that it had to be rejected because the information was written by another person for the address and the name. I don't remember that. It may have happened, but I have no recollection of that.
Commissioner Jackponi's first question, the staff, the objection did not include the number of entries that the name and address were written in by the collector. They simply attached those specific sheets to the objection, which we are making copies of now. But those sheets have a mixture of signatures that were invalidated, that were accepted, that were invalidated because the signature did not match or the address or the voter was not found. So it would have been up to the staff to make the determination which ones the objector was objecting to, the petitioner was objecting to. So they were included with the objection, but they weren't identified as is laid out in the regulation to identify the exact sheet and line number that are being objected to. Otherwise, it would be up to the staff to identify which lines were being objected to specifically, and that's why they were not included in the slide here.
Gonna pause.
To me, that's pretty significant because now the objection is leaving it up to our staff to determine which signatures they're actually objecting to.
And the response to that, if I may, is all of them. And this
All of
form does not allow that, because if you look at the form, it's on the bottom, you got the little letters, and it's not applicable when somebody's challenged on a legal question. And I had this conversation with Kathy at the Secretary of State's, and I was like, I'm not gonna file the form, but let's file it so we can say we filed it. But they were brought in and incorporated by reference with the narrative that went in with the petition.
So you're basically saying that if the board adopted your position, at that point, they or you would have to then identify every single one of these?
If the board adopts the position, I think that candidate Guttrow would concur, he's not going to meet 1,000 signatures if you adopt that position, and he's not on the ballot.
Okay. But whether or not
If
that's
they
true.
vote them all out.
You're asking them to knock out a section, so
That's-
Yeah.
I will add for the board that the addendum, and with the petitioner, Council Pagliarini is mentioning, he did not complete. He wrote on there, form is not applicable. However, he did provide those particular lines on page 4 of his objection, of those signatures, which could have been included on the addendum, but the staff recognized that he didn't include that on the agenda, the addendum, but he did provide the information for these 11 lines, which the staff did research and has ready for you to review today. He could have also included the signatures in which the name, the voter did not provide their name and address on those additional sheets as well, but the petitioner did not.
For me, I would agree with counsel that they have a very short window to object. The forms are not, I've sat on that side of the table. I would agree with him that if we take this legal position, that it would affect the qualification of the candidate. I don't think there's any dispute about that. I don't even think the candidate would dispute that, although he disputes the premise, but I don't think he would dispute that if we agree with him, everything's thrown out, correct? Or enough are thrown out that you wouldn't have 1,000. Okay. So I agree with that. I don't want to hold him to, hey, you didn't give us the specific line by line, so we're not going to hear it, at least from me. Anyway, I don't know how the rest of the board feels about that.
No, I agree. Did you have something else, Commissioner?
Without having seen the forms, is it council's contention that every single signature on all of these forms was filled incorrectly, was signed without the address?
I think by a preponderance of the evidence, the vast majority were. I will not say conclusively every signature, but the vast majority. More
So,
than
again-
69, I can say with certainty.
Okay. But again, that would leave it up to either our staff or us as a board now to look at each single one and determine.
I think you can reasonably look at an entire sheet in one glance and see commonality of the same hand.
Okay, I'm going to take a look at it.
Should we move to hear from the candidate or pause?
Yeah.
To,
So long as Mr. Connors is done with. Okay.
yes, okay. Okay, Mr. Gotra.
Hello, everybody. My name is Jay Gotra. I'm an independent candidate for governor. I am a bit anxious and intrigued at the same time, so please bear with me if I stumble a bit. When Ken filed this objection through his attorney, his filing included a required form called the nomination paper objection addendum. Your own rule says this form must be included. Its whole purpose is to list by line, signature by signature, exactly which signatures are being challenged and why. He left it completely blank. He actually wrote, quote, form is not applicable, unquote. With respect, not only is this form applicable, it's mandatory. The addendum requires specific rejection codes, voter addresses, and a complete line-by-line breakdown for every challenged signature. The narrative has none of that. They are not the same thing. More importantly, Ken doesn't get to decide for himself which of your required forms apply. That's the board's call, and without the addendum, I generally don't know what I'm defending against. No list of names, no specific signatures, no count of how many he's claiming should be thrown out. You can't object to something and not tell anyone what you're objecting to. That's not an objection, that's a complaint. I'd ask the board to dismiss this solely on this factor. But I want to address what Ken and his attorney is actually claiming, because over 1,400 Rhode Islanders signed those papers and they deserve to be defended. There is no law, not in the statute, not in the board's own rules, that prohibits a collector or a spouse from helping fill in the printed name and address fields. Those fields are identifying information. The only thing the law requires is the voter's signature. Every voter on those forms provided that in person. Your own staff already reviewed these signatures and validated them with the same principles that apply to every other candidate. They came to the determination that 1,069 of them were valid, comparing it against every other candidate. They didn't use some sort of a special way to validate these signatures for me that they did for any other candidate. So if we're going to go back and start changing these laws or rules that we're talking about for my specific candidacy, then this has to be applied for every person who's running. It cannot be just for me. And what does that do to go back and apply rules that don't exist? Now, one more thing on the filing itself. He named specific petition forms he claims are problematic. Most of them were never submitted into evidence, meaning the 11 signatures that he actually spoke of, there was no supporting documents besides one of them that had it. I understand that, they were overwhelmed. Okay, I understand that there are limitations that they were facing against, but the rule's a rule. They're sitting here asking me to have these rules strictly applied against me, but they're saying that they should be provided exceptions to the same rules because that's not convenient for them, or it's overwhelming for them. On top of that, all of these challenges he's making, only one form is actually evidence. And I'll leave the board with this. Ken knows ballot access law better than anyone else in Rhode Island. In 2008, he sued this very board to lower the signature requirements to make it easier for independent candidates to get on the ballot. He won. And now Ken is here using those same rules to try to remove an independent candidate from the ballot. The guy who fought to open the door is now trying to close it for me. And here's what I find hard to accept. His entire argument is that I don't follow the technical rules to the letter. But look at what his own filing did. He left the mandatory addendums blank. He submitted the wrong forms. He's asking the board to rule on signatures from forms that nobody submitted into evidence. And he certainly didn't put it on the list that we should have to understand what this claim even is. There is no claim. It's just a complaint. You cannot determine strict rule following from me while you're filing. Your own filing skips the requirements at your convenience. That's not a standard. That's a double standard. The voters who signed my papers made a choice. I'm asking the board to respect that choice, dismiss this objection, and let Rhode Island decide who their next governor should be. Beyond that, I'd love to go back to the law itself, if we can point that out, if you can pull that law. Reading that law itself, every voter shall sign nomination paper, shall sign, okay? And I know how the law works, and every word is very important. It does not say will, it says shall, okay? It's very important that we understand that language, because at the end of the day, that's what it's meant to be there for. It does not say has to sign. It doesn't say definitely must sign. It says shall, meaning it leaves rooms to say that is not, as important as that signature is, okay? On the other side of this, it clearly says that when it comes to addresses, the intent of addresses and first names and last names and initial is only to make sure that the voter can be identified, okay? It clearly states the signature shall be accepted as valid if the reasonable identity to be the signature of the voter it purports to be. It does not say that the signature has to, the defining information has to be written. It does not say the first name has to be there or even the last name. Yes, they're saying that because it does not say first and last initial can be there, first and middle initial can be there, it doesn't mean the last one can't be there. But that's not what the law says. The law says this is identifying information to validate the signature. And then beyond that point, of course, this is grossly misconstrued. What they're saying basically is because they're making an assumption, which they claim is not fraud, okay? But at the same time, they're handwriting experts, and now they want you guys to be handwriting experts to go back and determine who wrote what. Most of these signatures were collected at a wall. If you see the penmanship the same, it's not the same. The only thing that's the same is the pen color, because these were the same 3 to 4 pens that were on the table that people would use to sign. If you closely look at these signatures, they're not valid. Beyond that, if there is no proof of fraud, there is no reason for the board and its staff to do the work to find proof. It is the burden of Ken and his team to provide that information, not us as a unit to come to that outcome. That is my position. My position is this conversation shouldn't even be happening. The people in Rhode Island gave me signatures. We are more than happy to go to 157 because I'd like to address that one specific page that they brought up, okay? And I'm more than happy to take any more questions that you may have.
Thank you. Any questions for the candidate? No?
No, I'm actually prepared to make a motion. Madam Chair, I will, again, with the discussion from, my fellow commissioners, make a motion to deny the petitioner's objection as to any of the addresses that may or may not have been entered by someone other than the signatory on the papers.
Second.
Okay. We have a motion and a second. Any further discussion? Yes.
I just want to clarify this because I think it's interesting, both points that the Attorney Pagliarini brought up and candidate Gatra. So from my standpoint, the attorney is asking us for a strict interpretation of 1714-8. I'm not an attorney, I should mention that. But I agree generally that it basically every person shall sign in person with their place of residence. I think basically it says that the person shall do all of those things. I agree that that is true. I have a tendency to agree. So, but that being said, I also agree that the rules say that you need to specifically file which signatures and issues you have issues with. So while I'm fine that the 11 mentioned here are not on the paper, the other ones on the paper 157, which I think we just got a copy of, are not listed out. Not all of those were accepted. So we would have to literally go through and find out which ones the block campaign was trying to have an issue with. And I don't think that that's appropriate. So I think if we're going to strictly interpret the statute, we should strictly interpret the rules as well. And so for that reason, I plan to support this particular
And
motion.
can I just add one more thing to that? It's super important.
I don't want to say anything
Sorry.
right now.
Yeah.
Yes, sir.
Is that a motion to,
Commissioner Khan. Oh,
we have one motion pending. And then Mr. Jackaroni, are you asking to,
No, I'm just,
Amend?
we had a motion in a second. I was just, for discussion purposes, indicating why I plan
Okay.
to support it.
go ahead.
And I appreciate that and agree 100% with Commissioner Jackaloni. I believe that it's the objector's responsibility to list which precise signatures would be objected to. It's not, that's their responsibility. And I don't think it's the board's job to decide which ones are objected to and which ones not. So for that reason, I'll also be supporting the motion.
I agree.
And Commissioner Crowe. Just clarifying from where the 11, those were
Yeah.
identified. So that, we'll take that up separately once.
Yes,
Okay.
he has a number of challenges. You can take them all up separately, assuming that you don't find that it's now moot. But yes, you have that. You can go through each one of these.
Okay. Okay, anything else? Hearing none, all in favor signify by saying aye. Aye. Any opposed, abstentions? Commissioners, motion passes.
So may I ask a question on your
Yes.
decision?
Yes.
So are you saying to the next candidate that a collector may or may not write in column A and column B, or are you rejecting this on procedural grounds? What is the guidance of the board for the next candidate?
Well, I mean, my motion, and I don't know if everyone agreed with it, but the purpose of my motion was with regard to, for example, a collector comes to my home. I fill out my address. I not only sign that, oftentimes my wife or my child may sign that as well, and they haven't filled out their own address. So my motion was toward the premise of the statute. And I personally don't believe that the statute has that requirement in it, that each person has to write out their own address. That's just my personal belief. I agree with counsel on that. And I agree with counsel's position on that. But if you're looking for some far-reaching directive, that's not what the motion was intended for.
Yeah, I mean,
But
I
Ray,
think
you could
that-
probably speak to that.
I
better.
think Mr. Giacoboni's comments were expressed, but the motion was the motion, seconded, and then it was approved or unanimously, but that would be the extent of it. So it was on the substantive ground.
I mean, certainly I wouldn't be averse to us providing some directive to the local boards on this at some point. And sending that out to the public as to, what they should do with these nomination papers, because we see it every election. So I certainly wouldn't be averse to that, but I wasn't intending the motion as that. I wouldn't intend to speak to my colleagues in that, speak for my colleagues, I should say. But I certainly would have no problem if the board decided that we wanted to do a directive or something. That wouldn't, again, through the chair, if she decided, let's put a directive on the calendar and discuss it, I wouldn't have a problem with that either.
Yeah.
But that wasn't my intention. So. Now, Ray, if that only
So-
leaves us 11 signatures, do we?
I think,
What would be your
so
suggestion?
the doctrine of mootness may very well apply, but what you should do is make that determination. You should make a determination that the balance of the challenges are not ruled upon and are being denied or dismissed rather because of mootness. But we should have a record on that, just showing what the numbers are.
Of the 11?
So we just have 11 others that would be affected. Do you agree with that? That just 11 others would be affected by
There's
this?
just 11 others,
All right.
but again, I seek guidance.
Yep. Yep.
And even if 11 was struck, he's still on the ballot, so.
Yes.
I mean, I think if the question before the board brought by the challenger was susceptible of evading review ever, then perhaps we would, I would say we would consider the motion because it may actually give guidance to other litigants or other people who come before us. At least in my judgment, and that's up for the board, I don't see this as a question that will likely evade review. In a different fact pattern, a different circumstance, you very well could make a ruling that is crystallized because you have people who could be affected by the outcome. And I think it's always better to wait for that dispute rather than just do it in almost like a hypothetical way. So I would disagree that there's a need to rule on it to help future litigants because it's something that shouldn't evade review. We should be able to get to this point if it's something that keeps recurring, which it hasn't so far.
Yes, Mr. Gotra.
Again, coming from this side of the table, I mean, it's kind of like, it's like life, how it's perceived. Ken used to be here, years ago, right? So I mean, looking at from my perspective, I'm saying, this whole process is built to be fair. It's not to be regulated to a point where, valid candidates that are not being accused of fraud can't have a chance to run. That's the whole purpose of this board. And again, sometimes I think regulation is what we all want, but it's not what require. I mean, if there is no proof of fraud, we have determined from past, even inquiries that nothing is broken. So it's like, again, we're trying to fix something that's not broken just because somebody's bringing it to the court. Again, standing from this side, I don't believe there should be any new guidance there. I mean, I believe there were 469 signatures that were disqualified, okay? And to be honest with you, if I go back, I believe those were harshly disqualified that I believe I could have had a case. But at the end of the day, I believe in the fairness of the system. And that system, that one person that was disqualified was using the same metrics for every person, right? So that's what makes this so uniquely special, because none of this is done by one specific person. It's done by a group of us together that stops fraud from happening in this system, right? So I think, again, I believe the system, as I'm going through this process, is a very fair and honest process, okay? And again, sometimes we want to keep over-regulating things that are not broken. It is my opinion that there should be nothing that changes, because this system in its specific way is working fantastically. And you guys are doing a great job, and that's my perspective in it.
Yes, go ahead, Commissioner.
I'd like to say that I believe that the 11 have merit. However, on the basis of mootness, I'd like to make a motion to reject the objection for the rest of the 11 signatures.
I'll second it.
We have a motion and a second. Further discussion, Commissioner Giacone.
Well, I agree that this particular case is moot. I do think that we need to revisit this and put this as part of our guidance that we send out, because we were very specific after a couple of years ago when we had some incidents regarding signatures to put together. I think the board the staff did a great job putting together guidance. It's hard. People don't run for office every day. There are new people entering all the time. We need to help them to understand. It's best to try to do their best to follow the rules. That's what I'll say. So
I agree
I
with
hope
that.
that this is something that we can revisit at a later date.
I agree with that. And Director, you can make note of that for a future discussion. Okay. Anyone else? Hearing no further comment, all in favor signify by saying aye. Aye. Any opposed? Abstentions? Motion passes.
Thank you for your time.
Thank you both.
Thank you.
And on the same, it's the same agenda item, but now we will move to Allison Kane, State Committee Woman, District 45, Democrat. And do we have anyone here? Yes, sir. Could you please state your name?
Sure.
It's on.
It's on? All right,
Yeah,
thank
don't-
you. All right. I won't
Don't
touch it.
touch
Yeah,
it.
yeah. So my name is Thomas Kane. I am the chairperson of the Cumberland Democratic Town Committee.
Okay, great, thank you. And Ray, are you taking, sorry, you're writing.
Yeah, on this one, I don't really have any guidance to provide. It's pretty straightforward. I would say that based upon the role that Mr. Kane has, he would have standing as a chair of the party. So I don't know if, Mr. Kane, you're going to be just making legal argument. If you think you may be presenting some underlying facts, we're going to ask that you be sworn in.
So I do have affidavits that were signed over the weekend from some of this
Endorsers?
endorsers whose signatures were invalidated. But I can present those.
Okay.
If that's acceptable.
That is acceptable, yep.
Go ahead. Yeah.
Ray, if you can just, and I know there's not another challenger here, but you could just acknowledge what the cure process is for whoever's listening or whoever's on the board. The cure
pro-
process on these signatures with the affidavits, if you could just address the affidavits
You mean,
and the
with-
propriety of the affidavit.
so we do have a mechanism that's allowed. I'll say that under almost all circumstances, we're reluctant to have the board listen to hearsay evidence that's made by a declarant outside of your presence on an assertion to prove the truth of the matter asserted. So that's hearsay evidence. We don't typically allow it. Our regulation in this case does allow, because of the very clipped timeframe, does allow the challenger to bring on a form that we have an affidavit where it attests that the endorser is actually this person who signed that nomination paper. So somebody who's been before a local board, has a signature rejected, a challenger can come in and provide the board with affidavits suggesting the exact opposite, that they actually were the person. Now, if the other candidate is present, they can review that. They could ask that the person be subpoenaed, any number of things, but that is something that is allowed. And if the board accepts that affidavit, it could, as you're saying, Vice Chair, that could cure the defect or correct the determination made by the lower board. Does that help?
It helps me.
Okay, okay.
And I can't determine, so would we be swearing Mr.?
At this point, all he's going to do
King.
is, let's start out with you presenting your affidavits. We're going to mark those affidavits as, okay, we don't have any copies right now? He probably just gave it to us, right? Okay. Why don't we take a break for a minute and just make copies of that for each of
Great.
the board members? And we'll mark all of the exhibits as petitioners 1. We might break it down like 1A, 1B, depending on what he presents.
I will say that Mr. Kane did provide line by line what he was objecting to, for which signatures and which page numbers, line numbers, and the staff did go ahead and prepare that. So if this board would like to see those signatures directly to make a ruling on each one, as you can see on the screen there, 5 accepted signatures would place Allison Kane on the ballot.
And those are the same ones you provided us in writing here.
Correct, yes.
Well, I was just going to say, should we still wait because we do have affidavits that might coincide with some of the signatures we'll be looking at anyway, right?
Are the affidavits separate? Are we just looking at like a signature comparison on the ones
We
that are?
can-
You know which ones the
Do either.
affidavits don't apply to?
Yes, so I have 5 affidavits
Okay.
that I was able to obtain over the weekend.
Okay.
So the other people just unfortunately weren't available to.
So we can review, yeah, we can review the ones that don't have affidavits while we wait so that we're not keeping people.
We don't know which one.
Well, the first one.
think
on-
he
on
does.
I have something that says Form 3, Line 10, Kerry Feather. Is there an affidavit for that
There
person?
is, yes. So
Okay.
I have an affidavit from Kerry Feather, Benjamin Feather, Campbell Feather, and then 2 of the finders. I apologize, I don't recall.
Brooke?
I think it
Brooke
was-
and
I think
Emily,
it was
or-
Brooke and Emily. I don't believe Nathan.
Okay, well, there were only 3 finders, so we could
Yes.
start on.
And it was everyone below that. I
Sure.
didn't get an affidavit.
Let's start, where are you, 23? 24. Okay, let's start on page 24. And then we'll,
So Form 5, line 17, that would be after the last finder, correct?
yes.
Everyone agree? That is Josh Caetano. And you can see, we did scan in the nomination paper there on the left. And you have copies in front of you as well. And the CVRS signatures are over on the right.
I see similarities in all of these.
Move
Sure
we
about
accept the
others.
signature?
Moved and seconded to accept the signature. Any other comments?
I'm
Hearing-
sorry, so that's for Josh Caetano?
Yes. All in favor signify by saying aye.
Aye.
Aye. Any opposed, abstentions? Motion passes to approve the signature of Josh Caetano.
The next signature is on Form 5, line 18, Ryan Caetano. Nomination signature on the screen is on your left, and the CBRS signature, the only one that we have on file, is on your right.
I feel the same.
Move to accept the signature of Ryan Kitano.
Second.
Moved and seconded to accept the signature for Ryan Caetano. Any further discussion? Hearing none. Thank you, Tully. All in favor signify by saying aye. Aye. Any opposed, abstentions? Motion passes to approve the signature of Ryan Caetano.
Next signature is on Form 6, line 4, Mark O'Connor. Nomination paper signatures over on the left, and the CVRS signatures, we have 3 of them over on the right.
Let's,
Well, it's the top one, right? Is that correct?
That is
There are two
old.
signatures on
That
it.
is old enough, yes, to when the witnesses were required for, on some
Oh, well.
occasions, 1992, for voter registration. The bottom right are DMV signatures. The bottom right signatures are DMV. That top scanned one is his top signature, the top one of the 2 on that form. Excuse me, the bottom one of those 2, next to the date. Or the top one, excuse me.
Madam Chair, and
Yes.
you said, Director, that those are, DMV signatures?
Lower right is the DMV, yes. DMV, excuse me, online voter registration, that is the OBR.
Okay. Thank you.
I mean, if you look at that.
But this signature just looks like an initial.
mhm.
I move to reject.
Second.
Moved and seconded to uphold the rejection of this signature. All in favor signify by saying aye. Aye. Any opposed, abstentions? Motion passes.
That was a reject.
Yes.
Yes.
The next signature is Form 6, line 5, Lisa Ferrera.
Excuse me for a minute, Miguel.
Yes.
Mhm.
Now that we have these affidavits, should we switch to those or continue on here?
Maybe just
We have a
finish,
few,
'cause
we have a 3 left.
I
so-
know, but we only have 4 more.
Oh, yeah, one more?
I mean, might as well if we're saying you gain back
Yeah.
10 signatures. I don't think that's a bad thing, do you?
So this is for Lisa Ferrera. You have her signature on her nomination paper on the left and her 3 signatures over on the right.
Move to accept.
Second.
Moved and seconded to accept. All in favor signify by saying aye. No.
No.
2 noes. The ayes have it. Signature accepted.
The next
Next.
signature is Form 6, line 6 for Miranda Badawala. Nomination paper signatures on the left, and over on the right, you have a single hard copy signature, wet signature.
Second.
Moved and seconded to reject. All in favor signify by saying aye. Aye. Any opposed, abstentions? Motion passes to reject.
The next signature is Form 6, line 8, Farzad Batawala. Nomination on the left, and the single wet signature is over on the right.
Move to reject.
Second.
I mean, I think
I see.
for all intents and purposes, they do, it's a scribble. What they do, it's the same scribble. We have a motion and a second to reject. All in favor signify by saying aye.
Aye.
No.
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 Who's a no? What are you?
I'm an aye.
What are you?
I'm a yes.
So that's 3 and 3.
Okay. It's a tie.
Does not.
The runaway.
Motion fails.
Motion.
Do we have to have another motion? then? Or
You don't
no,
have to.
we just move-
The lower decision
Was-
stands.
Was that motion to
I-
reject and it failed? Is that
Yeah.
what it was?
Correct.
So do we need another motion to
You need
accept?
A
or-
motion to approve would
Motion
fail
to, I'm
too,
sorry,
so-
motion to reject the lower determination, right? And
to-
that didn't carry.
So then it just,
So it's still effective.
okay.
You can do, I guess you could do another motion if you want, but it's not required.
Right. I mean, the results would be the same in the
It should
motion.
be.
So a motion to approve it
Likely,
would
yeah.
be 3-3. I would-
Okay.
So that would be inconclusive, or how would we?
So it's.
It's not,
it
it's,
stands.
it's, right.
Whatever the lower board said.
Determination
Okay.
is the determination. It's
Got
not
it.
disturbed.
Last one before we move to
The
the
last-
affidavits.
Last signature's Form 6, line 16, Ronald Fournier. Nomination on the left, and we have two signatures for Mr. Fournier over on the right. The top one is a wet signature.
Yeah, I don't see it.
Motion to reject.
Moved and seconded to reject. Any other comments? Hearing none. All in favor signify by saying aye.
Aye.
Any opposed? Abstentions? Motion passes to reject. And now we'll move to the 5 affidavits. Ray, how would we just review these
Each
and
one.
just
Yep.
each one individually?
Yes, each
Okay.
one individually, they've actually been marked, thank you, as separate 1A through.
Now, just to point out, I believe there were 6 signatures validated in that last,
Do we have 6?
No,
6 signatures.
3.
I have 3.
You have
I
3?
have 3.
Okay.
3 were.
I wasn't keeping
3 accepted.
3, yep.
Yeah,
You have 3
and 4 that we didn't.
that we didn't. Okay. And the first affidavit is Emily Taylor Finder.
I move to accept the affidavit, I move to accept the signature of Emily Finder as corrected or as cured by the affidavit.
Second.
Moved and seconded. All in favor signify by saying aye. Aye. Any opposed? Abstentions? The ayes have it. Next is Nathan D. Finder.
I'll move to accept the signature of Nathan Finder based on the affidavit.
Second.
Moved and seconded to accept. All in favor signify by saying aye. Any opposed? Abstentions? Motion passes. The next is Carrie E. Feather.
Again, I'll move to accept the signature of Kerry Feather based on the submitted affidavit.
Second.
Great. Moved and seconded to accept the signature. All in favor signify by saying aye. Aye. Any opposed? Abstentions? The ayes have it. Motion passes. The next is Benjamin B. Feather.
Say motion
To
to accept.
accept the signature of Benjamin Feather as cured by the affidavit.
Moved.
Second.
Oops. Moved in many seconds. All in favor signify by saying aye. Aye. Any opposed? Abstentions? The ayes have it. And last is Campbell E. Feather.
To accept.
Moved and seconded to accept the signature of Campbell E. Feather. All in favor signify by saying aye. Aye. Any opposed? Abstentions? The ayes have it. And I believe that's
Yeah, just
8
Oh, I'm sorry.
plus 8.
I'll see.
So would we need a motion to officially approve Allison Kane being on the ballot?
Yes.
After? Okay.
So moved.
Second.
Moved and seconded to approve Allison Kane, State Committee Woman, District 45 Democrat, to be placed on the November ballot. Is it September?
September.
And is there a primary?
September,
So the primary and the general ballot, or the primary ballot, sorry, it's been a long day. All in favor signify by saying aye.
Aye.
Any opposed? Abstentions? The ayes have it. Please extend our congratulations to Ms. Kane for
And-
being on the
and
ballot.
Yeah, thank you
Before
so
you
much.
leave, let's,
Thank you.
just so the administrative record is clear, we'll have nomination paper objection filing. That'll be Exhibit 2, because we already have the affidavits as Exhibit 1. And then I believe as Exhibit 3, we should have the document that the staff prepared for the signature comparison, so we have a full record. That's it.
Thank you so much for your time.
you
I
very much.
appreciate it.
Thank you for your work.
Thank you. Have a nice day.
Okay, and I believe that the director has recommended and council has recommended that we move agenda item number 3 and number 4 to Thursday's meeting.
Correct.
Okay. Do we need a motion to that effect?
I think technically it would be good to do so.
Okay. Do we have a motion to move agenda item number 3 and 4 to Thursday's meeting?
So moved.
Moved and seconded. All in favor signify by saying aye.
Aye.
Aye. Any opposed? Abstentions? The ayes have it. And with that,
Motion to adjourn.
you're so good.
Second.
Moved and seconded to adjourn. All in favor signify by saying aye. Aye.
I know you like them.
No opposed or abstentions. And the meeting is adjourned at 5:25 PM. Well done.